You decide to bring a lawsuit against a doctor who you believe caused you harm. But there's a problem with your case. There's a gap of time where the doctor told you to do something and you didn't. During the course of your trial, during jury selection, do we have to tell the jury about this particular problem? You want to know the answer? Come join me as I'll share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law in the state of New York. The answer is absolutely yes. I want to tell the jury about it during the course of jury selection. Now, during jury selection, we can't go into a lot of detail, but I have to tell the jury about this. Why? Because I want to take away the defense's thunder. And I also want the jury to know that there's a problem. I want them to recognize that we have a gap. And now that gap could have significant implications. And I have to try and understand what the jury believes about a patient who's told to do something and fails to do it. Do you think it's bad, Mrs. Jones? Yes, I do. What about you, Mrs. Gonzalez? What do you think about that? Are you closer to somebody who says, listen, I have to follow the doctor's instructions 100%? Or am I okay if I'm feeling better not to do those things? I have to get the jury's understanding and what they're feeling about that type of scenario in order to understand whether that person is right to sit on this particular jury. Because ideally what I want to do is to get their feelings and to get them to recognize that it is our claim that that gap in time did not cause or contribute to your ultimate injury. And if I can get them to be open to that possibility, now it's significantly different than if we kept it concealed and didn't say anything about it. And now the defense gets up to talk to the potential jurors and says, ladies and gentlemen, what Mr. Oginski didn't tell you is that his client missed all of these treatments. Why? Because he failed to follow the doctor's instructions. How do you feel about that, Mrs. Jones? Do you think when a doctor tells a patient to do something, they should do it? Do you think it's for the doctor's own good or for the patient's benefit? And now the defense attorney is going to do everything possible to show to the jury that this patient, this injured victim, that the problems all arise from his own actions and not from what the doctor did. So why do I share this quick information with you? I share it with you because this comes up on a regular basis involving cases of accidents, medical malpractice, and even wrongful death matters. And I recognize you watching this video because you likely have questions or concerns about your own particular matter. Well, if you're contemplating bringing a lawsuit and your matter happened here in New York and you've got questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, @oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.